But I'll hope and try and convince you that it is permanent. I will try and convince you. I know, your lordship says it's debatable, and it is debatable. There's no doubt about it.
So both things are debatable means both sides will argue this point out.
It's really debatable. But I tell your lordship, why it is permanent. Now, for the moment, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, so far I've only referred to provisions of this Constitution. But your lordships will have to look at the Constitution of Jammu and Kashmir, because that Constitution, was framed and cleared in 1957. So, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, you can't do anything more than that. Right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. Yeah, I'm sorry, my understanding is right. Before we go to that, let's kindly see the volume 1. Now, let's kindly see, this is the Constitution of India as applicable to Jammu and Kashmir just before abrogation of 370. Your lordship has that?
Part 4 doesn't figure in it at all.
Yes. And there's no order omitting it.
This is which year?
This is just before 370 was abrogated.
It's taken from a book of 2016, but it's as it stood there.
Now you see here, Madad, after part 6, you have part 11.
Part 6, what page is that, Mr.
Madad, part 6 is at page PDF 48. And the next is... Yes. Part 11 is page 49. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why, the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only, the word which seems to indicate that these are the parts, the provisions which will apply.
So that's really... now, in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957.
But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the Constitution to Jammu and Kashmir. They never treated it as if all provisions apply. The really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the learned AG on that.
Now, we move on to what happened in 1957 when the Constituent Assembly drafted this constitution and was adopted. Right. And remember, the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want...
57, what happens at 57? Let's see then.
Yeah, but I'm just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then, 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and like any other state. They chose not to. And you will see that, in the Constitution itself. I'll show, it's better we look at the Constitution.
There is no dispute about the proposition. 370 remained in the Constitution.
Yeah.
So nobody is arguing that 370 was not there. Otherwise, where was the occasion to abrogate it? Only issue is whether it requires a permanent character, which cannot be touched, or whether there is a methodology, right or wrong, there is a methodology by which 370 can be abrogated.
Correct, correct.
The first part of your argument, as I understand.
Correct.
And in the alternative argument is, even if you don't accept my first part of the argument,
The methodology was wrong.
methodology was wrong.
Sir, I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is continues always. Second part is transitory because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner
Yes,
whereby some part will go away or become
Yes.
otiose, and some part becomes otiose because in 1957, some
Correct.
other part becomes otiose
Correct.
later on. So you say one has a permanent feature. That is our
the
argument.
Constituent Assembly effectively had a choice to exercise three or to allow one
Till
to continue forever.
1957. Your argument is all these choices were available only till 1957.
Yes, that's our
That is your argument.
So much. No, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the president as the Maharaja of Jammu and Kashmir,
Correct.
acting on advice of the Council of Ministers for the time being.
Right.
Now, what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we
Governor-
get that? Because the explanation says government of the state means.
Well, I'll show that to your lordship. That's also there, madam. If it's part of the constitution, madam. I'll show that.
This explanation was introduced in 1952. This ex-
There's a difference of opinion here.
Well, leave it. Let's, you can.
Of us, not. Their case is that 2 and 3 may cease post 57. But the some of us who heard is that no, the entity goes if we read clause 2 carefully. So this is that difference of opinion.
So your submission.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the governor.
67.
Yes, 1965 order.
65. So till 65, did the Maharaja continue to
Yes, madam. Then,
There were separate powers of Sadr-e Riyasat.
Yes.
The
but madam, ultimately,
equivalent of chief minister was called the prime minister.
Yes,
for
that's
some
correct.
period of time.
But in
Those
65, madam, it was
were,
the governor.
removed.
There's an order to that effect. So be that as it may, madam, I think we're traveling a bit too far at the moment.